We turn now to the Friday Supreme Court decision, which preserves access to a widely used abortion pill for now, while the legal process in the lower courts continues. Chief legal correspondent Jan Crawford joins us. Jan, it's good to have you back here. This was the decision you predicted, 7-2. The dissent coming from Justice Alito. Clarence Thomas also objecting. The Supreme Court is keeping the drug available now. So what happens next?
Well, that's right. I mean, the bottom line is that this drug will remain available nationwide without any restrictions while these appeals play out. And that could take at least a year. I mean, even though this case is really on a fast track, there's an argument next month before a panel of judges of the U.S. Court of Appeals for the Fifth Circuit, which will decide at some point whether that lower court judge in Texas was right that the FDA improperly authorized Mifepristone some 2 decades ago. But regardless of whatever the appeals court decides, whoever loses is going to go right back to the Supreme Court and ask the justices to step in and decide the merits, whether the FDA properly followed the right steps when it approved Mifepristone in 2000, and then when it agreed to make it more widely available, easier for women to get in 2016. That will set the stage for a major Supreme Court case on abortion access, possibly as soon as next year.
An election year, too. Jan, there's great irony in the fact that the Supreme Court sent the decision on abortion access back to the states after Dobbs. And now we're talking about going back to the Supreme Court to decide on it again. Will the justices, how involved will they get? I mean, you think this is inevitable? It ends up there.
Well, I think it's going to go right back to the Supreme Court because whoever loses will appeal it and ask the justice to get involved and decide it. I don't think that they will. I don't think they'll ever reach the merits. Well, I think they'll have to hear it, but I think they're going to dismiss it on standing grounds. They're going to say that these challengers who went after the FDA authorization weren't able to show that they had right to be in federal court in the first place. And let me just, those are kind of bedrock conservative legal principles that really go to the heart of this case. To get into federal court, you can't just be upset about some issue. You've got to show you've been harmed, that you have a stake in the case. It can't be just something speculative in the future. And I think that's a real problem for the challengers here. Now, the lower courts saw it differently. The Trump appointee federal judge saw it differently. But these conservative justices take those kind of standing issues very seriously because it goes to the point of judicial restraint. And that's why what they're doing with this case is entirely consistent with what they did with Dobbs, the ruling that overturned Roe versus Wade and last year and sent it back to the states. What they're doing in this case is really saying, if they follow this rule on standing, that these challengers don't have business being federal courts. We're going to keep that kind of a high bar for getting into the courts. We don't want federal judges ruling on these social issues. That belongs in the political process. So the bottom line for this case, I think next year, whenever they get back to it, is I think they're going to dismiss it on standing. I think these conservative justices will join with the liberals and say the challengers don't have a right to sue in this case. It could be 8-1, possibly even unanimous.
Very quickly, a lot of scrutiny of Clarence Thomas. What do you think is going to happen to him?
Well, as you know, there's been reports that he failed to disclose a couple different things on his disclosure forms, vacations that were paid for by a really rich friend of his that he didn't disclose. The rules on that were not very clear. They were recently amended. So he said he'll report that going forward. I think the more problematic one is some property that he and his family sold to the same friend that wasn't disclosed. His people close to Thomas have suggested that's because he didn't make a profit on that, so he thought he didn't need to disclose it. The bottom line, though, is Democrats are calling for hearings. Republicans are saying this is ridiculous. This is politics. If it sounds like a mess, it is, and the Supreme Court could do well by looking at adopting its own code of conduct.
Jan Crawford, thanks so much for your reporting.